Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series, and today's program is privacy law. But before we get started on privacy law, if you're new to the Curious Lawyer series, let me tell you a little bit about it. At the Curious Lawyer, it's a fun, educational, interesting walk down off the beaten paths of law. Things that are not necessarily core to your practice area. It's just a fun, edutainment, educational way to intersect with the law in different areas that you may not be familiar with. And so we've done programs on dog law, where you learn all about how our favorite furry friends, if you're a dog lover that is, how they intersect with the law, contract, criminal, trusts, you name it. We've done CIA law, where you get to learn the origin from lawyers of the famous CIA phrase, "I can neither confirm nor deny." All sorts of programs like this. And these are programs designed to make you a more well-rounded lawyer, to educate you, to entertain you at the same time. And you will find, as many people have reached out to me as we've been doing these programs now for a few years, that these intersections give you ideas even in your completely different area of the law. It just gives you ideas and insights into analogies and metaphors and different things that you can use in your practice. Or it'll make you knowledgeable at cocktail parties about the types of questions that you get from non-lawyers. So with that, today we're going to look at privacy law. We're going to talk about the right to privacy. What is it? What does it mean? It's a phrase that obviously all of us within the law and broader society, non-lawyers even, all know about, all talk about. But what does it really mean? What's it rooted in? What's it grounded in? If you are asked what is the right to privacy, you may have some general understanding right now. But in 58 minutes, you're going to know all you need to know about the right to privacy. So let's get started and let's take a look at this first quote on the next slide. Recent inventions and business methods call attention to the next step, which must be taken for the protection of the person and for securing to the individual the right, quote, to be let alone, end quote. Numerous mechanical devices threaten to make good the prediction that what is whispered in the closet shall be proclaimed from the housetops. It's a quote from 2022, right? This is all about the NSA and cell phones and Apple Watches tracking my heart rate, my fitness, how much exercise I'm getting or not, as the case may be. Drones monitoring us with lasers to listen in on speech. 23andMe and Ancestry.com, where we hand off our blood to genetic testing and it learns all about us and our potential for disease or whatnot, sitting in a database somewhere, right? All of this is what the quote's about. Turns out it's not. The quote was written in 1890. That's right, 1890. And it was written by Justice Brandeis, who at that time was not Justice Brandeis, he was Louis Brandeis. Now, he was an attorney, and he really, before he became a jurist, even as an attorney with his partner at the time, wrote an article that was probably the seminal article in our constitutional sort of history that coined and created the idea of the right to privacy. And so in some sense, Justice Brandeis became the most seminal figure in the right to privacy history and the concept of the right to privacy within the concept of justice that we have today. And so that quote comes from Justice Brandeis. It sounds awfully prescient when you look at that quote today and you think about the stuff that we deal with today, those technologies I talked about. Let's keep moving along now, because what I want to talk to you about is, what is this right to privacy? Obviously, part of it is the right to be let alone. It's the idea to be able to have freedom from government involvement in certain aspects of our lives. But what aspects? So I think when we talk about the right to privacy, as you see here on this slide, there are three major categories or buckets, so to speak, that we can look at and we can talk about and we can define when we're discussing the right to privacy. One aspect is the freedom to control private information about ourselves as against others. So, internal information about us, whether it's what's in my blood, how much I weigh, who I texted what to, how tall I am, where I live, those types of informations. Private information vis-a-vis third parties, which could be the government, private people. It's also the freedom to engage in certain behaviors or actions without government regulation. And this rears its head obviously most when we look at the right to private sexual conduct with free from government intervention, or the right to control one's body free from government intervention and government regulation. And then there's this idea that fits within the right to privacy of what is the scope or what is the nature of our right to be let alone, to be left alone by the government, to be free from government monitoring, government tracking, government intrusions into our private spheres, be it our physical homes, our, in this modern world, digital homes, where so much of our quote-unquote home now is controlled and monitored by digital devices, whether it's our webcams in our homes or outside our homes, or the Ring doorbell you have, or whatnot. So there's this idea of the right to be let alone. And all of these strands of the right to privacy are I would say the double helix, but it's a triple helix here. But they're the strands that if you tie them all together, they define and exemplify what it is about the right to privacy. So what we're going to do today is disentangle these ideas and look at and understand what is the history of where these rights to privacy come from, what is the nature of our right to privacy today, so that you, the curious lawyer, can understand what privacy rights you have or you don't have in public spheres and in private spheres. And we are going to look at some of the most cutting-edge statutes that have just been enacted in a few states, and they're going to be enacted in more states, that look at privacy rights in the digital data age in terms of this tension between those who collect data, private companies and or government, and individuals who more and more are pushing state legislators to pass laws to protect the dissemination of information that's being collected constantly as we all engage with our Apple Watches or social media or computers. So let's get going and look on the next slide here at the question of where in the law does the right to privacy come from? What is the source of these different privacy rights and these different strands to privacy? One aspect you see here on the first box on the left is the Constitution, and we are going to look today at the constitutional turf that grows certain privacy rights. We're going to understand what is that playing field, what privacy rights grow out of that playing field, and what are the limits, the constitutional limits, either by definition or by other aspects of the Constitution that delimit the ability for privacy rights to go too far. We will also look at state statutory and common law and see certain even federal statutes that look at privacy rights. And so these are positive law enactments that have been created to define the metes and bounds of various kinds of privacy rights. And then substantively, the different types of areas that we will look at involve things like private sexual behavior, educating our children, home protection against intrusion, what are our bodily privacy rights against intrusion, data that's collected and controlled about us, physical or digital intrusions into our homes, and then what are our privacy rights in our own personhood, in our own self, when we are in, for example, public spaces versus private spaces, or even the right to control one's personhood from commercial exploitation by others. So let's go back to our history on the next slide here, because in order to unpackage the right to privacy, we have to start with a very, very important fundamental precept. The words right to privacy don't appear in the Constitution. So this idea that we have a right to privacy is one that we have to unpackage its historical roots to understand what is the constitutional lineage of this. And the first aspect of this program today will be looking at the Constitution. It's not mentioned in the Constitution expressly, and it's really Justice Brandeis' fundamental article that sets the stage on the right to privacy and contextualizes the right to privacy. We are going to look at Supreme Court cases that have adjudicated the existence in these limited constitutional forms of the right to privacy. And so here let's start again with another quote from Justice Brandeis. The first quote we looked at was from many years before he became a justice, and this is a quote from Justice Brandeis decades later when he was on the Supreme Court as a justice. And again, it is a case dealing with the right to privacy, and again you see Justice Brandeis really the father in some sense of the right to privacy in modern American society in terms of the law and how we as lawyers conceptualize it, value it, and understand it. And here again you have Justice Brandeis discussing and talking and railing against the risk to individuals from the modern technology age, the then modern technology age, which still echoes true today. So let's look at this quote. The progress of science in furnishing the government with means to espionage is not likely to stop with wiretapping. I mean, let's pause there. Those are pretty prescient words when you look at where we are in 2022. Ways may someday be developed by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home. Honestly, you can't even make up that quote. I almost fell out of my chair when I read it because I thought it's profoundly prescient for someone to recognize that the march of technology is such that it will do things that are unimaginable. And obviously, in the 1920s, it was unimaginable that there would be email which would allow papers to be taken from us electronically and then reproduced, or that there would be ways to spy into the home to figure out the most intimate occurrences, which now occurs obviously with webcams that are broadcasting over the internet where people can be hacked into and tapped into. So I find it as a pretty profound comment and quote from him dissenting in this case, and we'll look at this. But it goes to show this idea between technology and the march of technology and the right to privacy is a fundamental battle, really, between these two concepts that are in tension. They're in tension today. They were in tension when Justice Brandeis wrote this quote, and they really define the metes and bounds of our privacy rights. And the tension then comes to root when we see how common law courts and state legislators pass laws to sort of deal with this ever march of technology and what is the balance between technology and privacy rights. So we're going to look at the constitutional basis and scope first, and we're going to look quickly at and run through a few amendments that touch on different aspects of the right to privacy, and then we're going to get into some case law. So the First Amendment deals broadly with the idea of the privacy of beliefs and speech, which relate to an aspect of privacy. The Third Amendment talks about the privacy of the home against quartering of soldiers, and so that's in some sense, it's an aspect of the right to physical privacy from government intrusion absent sort of a profound need, for example, in the time of war. The Fourth Amendment deals more broadly with the privacy of the home and the possessions against government searches that are unreasonable or warrantless. And then the Fifth Amendment deals with another aspect of privacy, which is this idea that one cannot be forced to give up personal information that could incriminate themselves by the government. And that's a limited form, obviously, then of personal privacy over personal knowledge, data, facts that could be taken and used against you in a criminal sense. Let's take a look then at this 1923 case first, and this is Meyer v. Nebraska. And this dealt with a state law in Nebraska that prohibited the teaching of German language, or any foreign languages, but German language was the focus. And it prohibited the teaching of that in schools on the theory that this would inculcate anti-American ideas. And so a constitutional challenge was brought, and the U.S. Supreme Court held that that state law was unconstitutional under the 14th Amendment. And so we can look here at the quote of the holding of the Meyer Court to understand where this idea comes from that the law was unconstitutional. And it's rooted, as you see here in the quote, in ideas of fundamental privacy rights. So while the court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. And so you see here a very, very important holding rooted in privacy ideas, the right to acquire knowledge that one wants, the right to raise children as one wants without undue interference from the government. And these are all aspects of what are our privacy rights. And what's also critical about this case is, although rooted constitutionally in the 14th Amendment's due process clause, the court was very clear that these privileges, these sort of fundamental rights, privacy-type rights, have long been recognized at common law and were really essential to the idea of due process. And so it has this sort of constitutional turf, which itself is rooted in a broader common law concept of privacy-type rights that have existed. So that was 1923 in Meyer. And now after Meyer, we're going to go to 1927, and that's the Olmsted case, which we just saw the quote from Justice Brandeis dissenting. Now we're going to look at what happened in that case with the majority. So this is Olmsted versus United States, and it was a case involving a prosecution against folks for selling alcohol in violation of the Prohibition Act. And so we have to remember, of course, historically this was a time of prohibition and didn't go over well, obviously. Some of you may be having a drink right now. But nonetheless, the government was wiretapping phones to get evidence against bootleggers or those selling alcohol in violation of the prohibition laws. And, they gather the evidence, they prosecute Olmsted, and so this leads to his conviction, and then it leads to a case that goes up to the Supreme Court. And Olmsted claimed that the exclusionary rule required that evidence gathered by the wiretaps that was used to prove he was bootlegging or whatnot, it should be excluded. And the Supreme Court said, no, and this is a 5-4 decision, but the Supreme Court said the exclusionary rule only applies to physical searches. So a warrantless physical search of your body, patting you down, yanking something out of your pocket, for example, the Supreme Court said, yep, that would be excluded. But this wasn't a physical search. This was a wiretap done over, the early telegraph and phone lines that were in existence then. And the court then created this sort of distinction between physical intrusions and what we would call today as just sort of electronic type intrusions. So Mr. Olmsted went to jail and didn't get his conviction overturned. Now this is the case where Brandeis dissented. And his dissent becomes a seminal sort of foundational argument for later changes and developments in the right to privacy. And eventually, Olmsted, of course, is overruled in 1967 during the Warren Court, where the exclusionary rule was held to not apply to some arbitrary line between physical and non-physical intrusions. And here's another important quote from Olmsted from Justice Brandeis talking about the founders. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. So stop and if you just unpackage that sentence alone, it's a really significant sentence because this shows Justice Brandeis's perception, an argument that the founders conceptualized the right of privacy in a very foundational root sense. It's the sacredness of our individual, you, me, everyone watching this, everyone walking on the street, everyone's right to have their own thoughts, to have their own emotions, their own physical, emotional sensations as they experience and interact with the world and stimuli. And those things are at root private. And so what Justice Brandeis goes on to say is that they, talking about the founders, of course, they conferred, as against the government, the right to be let alone, the most comprehensive of rights and the most valued by civilized men. So this is where we get this idea that the right to be let alone is constitutionally foundational to our relationship with our government. But of course, in 1927, it didn't work out well for Mr. Olmsted, and Justice Brandeis was in the dissent. Now let's fast forward to the 1960s, where the Warren Court, of course, started repealing many of the prior cases and rulings and really expanded the right to privacy. And so we're going to start with Griswold v. Connecticut in 1965. And this case involved a Connecticut law that criminalized the provision by medical doctors or nurses or clinics, the provision of contraceptives to married adults, or to any adults, but including married adults, in terms of not being allowed to use contraceptives. And this is then taken up by the U.S. Supreme Court in 1965. And the court looks at that state Connecticut law, and it looks at that vis-a-vis the idea of whether the government, or in that case the state, but whether any government can interfere with one's right to engage in sexual behavior using contraceptives or not, and whether the state has simply overreached, because what we do in our bedrooms, whether we use contraceptives or not, among other things, of course, is private vis-a-vis the government. And that's the question. And so Griswold's seminal case holds this, that the foregoing cases suggest the specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. And here we see now, in a majority opinion, this idea of the privacy right being rooted. The right of association contained in the penumbras of the First Amendment is one. The Third Amendment in prohibiting quartering of soldiers, we talked about that earlier. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. And then the Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, those others being that underlying common law, natural law right that Justice Brandeis was talking about earlier. So, Griswold gets more specific about the zone of privacy, and here's a question they phrased. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring, and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. And so what's really fascinating is that is where the Griswold case came down. And so let's pause for a second to understand what was the state of Connecticut saying to justify this intrusion into what is this zone of privacy, to say that no, you don't have that kind of a privacy right. And this is what's a fun, interesting little chance we have now because of the modern technology age. We get to listen in on a few minutes to the oral argument of Griswold v. Connecticut in 1965. And thanks to our technology age and YouTube, we have the ability to hear it. So let's listen to this for the next couple minutes.
Mr. Clark, what you're touching on now leads me to ask, what is the purpose of this legislation in Connecticut? Your basic argument in your brief, and so far in your oral argument, is that this is well within the so-called police power of the state of Connecticut. And what is its purpose?
Well, if Your Honor, please, I think its purpose is
to increase the population of Connecticut, or to impair its decrease, or is it what?
If Your Honor, please, I do not hold that it is to increase the population of Connecticut. I don't think that this is we could make this claim valid.
So what is it? What is the purpose?
I think it's to reduce the chances of immorality, if Your Honor, please, and I use the words immorality here in a broad sense. That is, in one way, to act as a deterrent to sexual intercourse outside of the marital relationship.
Well, the trouble with that argument is that on this record, this involves only married women.
That is correct, Your Honor.
So how can you make that argument?
Well, if Your Honor, please, I think that on this record, that the statute is a valid exercise of police power.
Well, for what purpose?
And if Your Honor, please, on this record, that there is a distinction, and there has to be a distinction between birth control and the use of contraceptives. That is to say that all contraceptives involve birth control. But in order to practice so-called birth control, one does not have to use contraceptives. And that the state is able to take this position and take this distinction, that there are, if it be said, well, should married people be allowed to use these devices?
Yeah.
Is not the state going too far? I think the state can answer to that there are other methods available to married people.
Well, now, for what purpose under its police power? Assuming we're dealing now with married couples.
Well, if Your Honor, please, going back, Connecticut in the Nelson case cited the Byrne case in New York, and one of the reasons cited by the Connecticut court and the Byrne case was that it would not be, as a matter of fact, it would not be improper for the legislature to consider that Connecticut, as any state, has a right to look out for its own continuation. This is the population argument. I personally am not too happy with it, but...
Well, what argument are you happy with?
I think, if Your Honor, please, the only argument that we can honestly say is that this is a question of pure power.
Well, do you suppose the state of Connecticut could prevent marriage?
I think the state of Connecticut could prevent marriage on certain people, certain groups. Yes, if Your Honor, please. Between idiots, say, or age in marriage, I think If Your Honor, please, that...
But surely you'll agree with me that couldn't... I should think you'd agree with me that the state of Connecticut should say there'll be no marriages contracted in this state. Be no sexual intercourse of any kind, married or unmarried.
I agree with you.
Well, now, what is the police power purpose of Connecticut in telling married people, two people who are married to each other, that they cannot use contraceptives?
Well, I think, if Your Honor, please, it's to preserve...
what kind of morality? What moral purpose is
Well,
that?
if Your Honor, please, it is not unheard of that the use of contraceptives themselves would be immoral. Certainly, this is a view that has been prevalent in history right up to the last few years in most groups. In Connecticut, I'm citing the brief of our opponents in one instance of the number of Catholics and Orthodox Jews in the state. If you were just to put it on a numerical basis,
well, you'd have quite a different case if the state of Connecticut compelled all married couples to use them. That's not. That's when you'd run into the argument you're now making, that this violates the religious precepts and beliefs of certain groups.
This is true, but if Your Honor, please, it also would be more difficult for the state to control the result of what you might call dissolute action. That is, fornication and adultery. That's what it's there.
Well, I thought you and I had agreed that isn't involved here. We're dealing here with, by definition and on this record, with advice and the furnishing of devices to married women who ask for such advice.
Well, Your Honor, please, I think what we have here, that is true. We have here a center being used, and the witnesses that the state used in this case were, in fact, 3 married women.
Mr. Clark, inquiry, on page 15 of your brief, I don't know that I agree, but if you might provide an answer by reading what your court said in State versus Nelson. Doesn't sound like a very lofty attribution to married people, but that's the reason your court assigned. Page 15, State versus Nelson. You look at the next to the last paragraph.
Your Honor, please, that's what I was trying to get out, and I must say that I did it rather poorly.
That is the reason your state, I take it, assigns that morals are involved.
That is correct, Your Honor, please. The court held in Nelson, it, meaning the legislature, was not precluded from considering that not all married people were immune from temptations or inclinations to extramarital indulgence. And I think, if Your Honor...
That is the moral ground, then, upon which presumably your court has sustained this legislation under the police power.
I think it is.
That's the ground on which you're relying.
That is correct.
Wow. So there you had it. The state of Connecticut, when pushed and pushed by the Supreme Court justices, at root justified this intrusion into the right of privacy on the basis that it may encourage people to cheat if they're able to use contraceptives, and that's not good. So that's about as thin a ground as one can end up on ultimately, and the state of Connecticut lost that case. So let's now move to a few years later to 1969, and this is Stanley v. Georgia. And Stanley involved a prosecution under state law on obscenity. And as happens many times in constitutional cases, these cases involving privacy rights ultimately come to light in very weird ways with very funky fact patterns. And so this one is another example of something coming to light in the weirdest of ways. And so basically, the case was originally and really about bookkeeping and like sort of gambling, bookkeeping, and sort of doing gambling violations under state laws. And so cops had a warrant, and they went in to sort of figure out if, Mr. Stanley was involved in illegal gambling and bookmaking and whatnot. So they execute the warrant, they go into his house, and they search. Now, while looking for gambling and bookmaking papers, they come across a whole bunch of 8mm films. Now, stop and pause there, because this is just what's so funky about it. The idea that the 8mm films, like, that you would watch movies, would have evidence related to illegal gambling and bookmaking, hard to understand. But nonetheless, the cops sat down and watched Mr. Stanley's 8mm films. And then they arrested him for possession of obscenity, because the 8mm films were porn films. And so he's then prosecuted, convicted, and his case goes up to the U.S. Supreme Court. And the U.S. Supreme Court addresses this case within the context of the right to privacy. And so here's a quote from the court. Whatever may be the justifications for other statutes regulating obscenity, we do not think they reach into the privacy of one's own home. If the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds. And so at root, the court held that the individual has the right to possess and view pornography in their own home, and that can't be regulated by state obscenity laws barring the right to possess lawful pornography. And it's rooted, of course, in this fundamental right to privacy that they talk about in terms of the ability to be free from government intrusion into one's homes, and the right to be free to allow one to have what thoughts they want to have, to look at things they want to look at, and to view things they want to view without the government patrolling and controlling our minds. So, let's now move to 1972, and of course the case everyone knows about, Roe v. Wade. And this is the seminal case that was grounded in the right of a woman to have an abortion, and grounded in privacy concerns related to bodily autonomy and personal medical decisions, and the right to control one's body vis-a-vis the state. And of course, Roe v. Wade adopted the trimester approach, which provided varying rights of the individual to control their body vis-a-vis the state's right to regulate and control abortion. And it did it with a trimester approach in terms of the first trimester being the woman had full control over her body, the second trimester this kind of blended, and then the third trimester the state's interest was higher, and it was sort of built around the trimester approach. And of course, Roe v. Wade has stood the test of time, and in the early 1990s it was challenged again, and that was the famous case of Casey, which reaffirmed the core holding of Roe in terms of the right to privacy and the right to bodily autonomy and to control one's body in medical decisions, but didn't use the trimester approach anymore and used the viability standard as being the marker to start defining the different rights between the state and the individual. And of course, as we all know now in 2022, huge cases are on the horizon testing whether Roe v. Wade and Casey will stand the test of time or whether they will be abandoned and undone. And if they are abandoned and undone, of course, there will be a Curious Lawyer Privacy Part 2 on that. But if they are, it will actually be a fascinating example of this idea that we have a shifting pendulum on the right to privacy from the Supreme Court. And we've seen it already with the idea of Justice Brandeis dissenting in Olmstead and then eventually another court decades later going the other way. And here we may have another example of what are established privacy rights may be undone and whittled away by a court going another direction. And this shows how our constitutional privacy rights, because they are not so expressly textually defined, there isn't an amendment that says the right to privacy is, quote. Because we don't have that and we are subject to judicial interpretation, we are subject to changing Supreme Courts. And so this is why this aspect of the right to privacy is so profoundly interesting from a privacy perspective to see what happens. And who knows, if Roe and Casey are undone and that right to privacy then is unmoored from the Constitution as a basis for constitutional protection, we may see other cases undoing other rights. Maybe Griswold will be put back on the docket. Let's go to 2003, Lawrence v. Texas. And this, of course, is the seminal case that provided the constitutional right of privacy that allows adult consensual sexual intimacy in the home, that the state can't prohibit homosexual or other sexual type behavior in the home. And of course, this case is another example of reversing Bowers from 1986, which had rejected any such constitutional right as grounded in any privacy rights. And so it's another example of how the court over time can shift and change the nature of those rights, but it also means, because we don't have that express textual grounding, the rights can be seen in the eye of the beholder of the court, depending upon who's on the court. Who knows? This case may be tested again in coming years too. And so stay tuned for Privacy Part 2 as we see what the Supreme Court does. Now let's shift a little bit. We've seen the constitutional turf that has grown certain flowers, so to speak, if you want to work with a visual metaphor. And those flowers are different aspects of our right to privacy and what we have. But now let's look at some limitations on that turf. And the limitations come from the Constitution itself. It just will not allow certain flowers to grow, if we want to keep riffing on that metaphor. And so one aspect of this is to talk about public photography and just public space. What are our privacy rights in the public space? And so we have this issue that comes to light really because of this entire paparazzi industry that exists where people are photographed in public or now videoed in public, and that content is used and published in newspapers and websites and people's Instagram accounts or social media or whatnot. And so the question this raises is, what is the First Amendment right of the people gathering that stuff, of filming you, me, celebrities in public? What is the First Amendment right to do that in public spaces as a limit then on that person who's being videoed, their right to claim some privacy right to patrol and control the use of that? And so public spaces become very, very important places where we see the Constitution delimiting the individual's right of privacy. And so we have a collision of these kind of constitutional ideas here. And so one place to start, and an ideal place to start, is with perhaps, who was the most famous celebrity in the latter half of the 20th century. It could have been Jackie Kennedy. And this case involves Jackie Kennedy and her family being hounded by the original paparazzi. And this is the case where the word paparazzi first found its way into our legal lexicon and then even broader, public social discourse. But this is the first time the word appears in any case law. And so it deals with this collision of Jackie Kennedy, then Jackie Onassis, in the late 60s, early 70s, and her children going about their business in public and in private, and the issue of photographers and what paparazzi, this one Mr. Gaia, and what are the limits of their ability to hound and photograph and go after these people in public. And so let's look at the facts at least, because we need to understand obviously what was happening exactly to Jackie Kennedy Onassis and to her children. Gaia took pictures of John Kennedy riding his bicycle in Central Park across the way from his home. He jumped out into the boy's path, causing the agents concern for John's safety. The agent's reaction and interrogation of Gaia led to Gaia's arrest and then his action against the agents. Gaia, on other occasions, interrupted Caroline at tennis and invaded the children's private schools. So just stop and pause there. We understand some of the facts we're understanding are, it's not just the case of taking a photograph in public. It's a case of actually jumping in front of a kid on a bike, going into Caroline Kennedy's private school to try to get photos of her. So let's keep going. At one time, he came uncomfortably close in a powerboat to Mrs. Onassis swimming. So now we have a case of not just taking a photo of someone in a public waters, but cruising a boat up too close to her where she's swimming, and now her life is at risk. He often jumped and postured around while taking pictures of her party, notably at a theater opening, but also on numerous other occasions. He followed a practice, and this is where it gets really just remarkable. He followed a practice of bribing apartment house, restaurant, and nightclub doormen, as well as romancing a family servant to keep him advised of the movements of the family. You almost can't make it up. Someone should write a book about that. I mean, what an unbelievable story. I mean, he's out here, trying to romance Jackie Onassis' maid to find out what she's doing. And so the question then that this case raised, since he got arrested and had trouble, then he brings a First Amendment challenge to what was going on, saying that, I'm being harassed and I have the right to do this in public. And so the question, he was enjoined by the district court. And the question then is, did the First Amendment limit the right to enjoin those activities of his in public? And what the Second Circuit held is that the First Amendment allows broad news gathering and news making activities in public, but Gaia went too far. And so what the court held is that he went beyond any reasonable bounds of news gathering. And when weighed against what is, de minimis public importance of the daily activities of the defendant, Gaia's constant surveillance, his obtrusive and intruding presence, was unwarranted and unreasonable. If there were any doubt in our minds, his inexcusable conduct toward defendant's minor children would resolve it. The First Amendment then ultimately did not protect him from state tort exposure. And so that's an example of where the individuals assert a right of privacy, and they are they're in public spaces some of the time, but not all the time, but they assert a right of privacy. And the defendant says, well, wait a second, I got a First Amendment right to sort of do this stuff. And the court held, no, that privacy zone right of interest cannot be stopped by the First Amendment when it comes to telling someone that you don't get to intrude into their home, intrude into their kids' private schools, endanger them in public. Those are the limits. Here's a fun little aside about the case, because it is sort of the first time the word paparazzi actually appeared in an American court case. And so the trial court had said, and this is a quote, Newsweek magazine defined paparazzo as a, quote, annoying bug, end quote. Paparazzi, literally a kind of annoying insect, perhaps roughly equivalent to the English word gadfly. We emphasize that this trial court did not relate to news photographer, a news reporter, or a photojournalist endeavoring to get a story about our woman and her two children who were, in our opinion, fair game at least to be looked at publicly. So what ultimately happened here, and this is why it's such a fascinating case, just as a historical aside, since you're a curious lawyer, this is the first time that a court definitionally treated a paparazzi as not really a true news gatherer, but a pest. And so if you actually go and look in the Westlaw Federal Database and do a search for it, you'll find that it's the first time the word appeared. It's a word that we take for granted, and so there you have it in The Curious Lawyer, privacy and paparazzi. That then brings us, because we saw in that case we had tension between state privacy laws that were being pursued to seek an injunction and the Constitution. Now we're going to shift from, we've been in the Constitution, we've been where they're in tension, now we're going to shift to those state laws, and we're going to look at the state basis and scope of rights. And this really revolves around the idea of invasion of privacy torts. And these are the different types of tort actions that one can bring against others when their different aspects of privacy are invaded or damaged or injured. And this allows us to look at these torts to understand sort of the state turf. What are the metes and bounds of the state turf that give what kinds of rights? And so the four major types of state tort actions that we have across the common law in different jurisdictions, and not every jurisdiction is identical, but these are generally true against in almost all states. There are tort claims for the public disclosure of private facts, the intrusion into private matters, for false light, and for right of publicity, which is statutory common law in most states, but not all. But those are the four major zones that give different kinds of privacy rights to the individual, and we're going to now unpackage these. So let's look at the first one, which is public disclosure of private facts. In order to have a state tort claim for this privacy right violation, you have three general elements. The first is that there's a public disclosure of a private fact. The public disclosure is offensive to a reasonable person, and it's something that's not of any legitimate public concern. And that comes from a prototypical case I just picked, Schulman versus Group W Products, Inc. It's reported at 74 Cal Reporter 2nd 843. It's a California case, but it's not a particularly important case in the sense that it's a very standard recitation of the elements. What's important is we look at the third element. What's of legitimate public concern? And so for the third elements, courts look to different factors. And here are sort of three general factors that courts look to. They look to what is the social value of those facts being disclosed? How deep was the disclosure in terms of violating one's private affairs? And did the plaintiff voluntarily assume any kind of position of public notoriety vis-a-vis those private facts that were disclosed? And so this is sort of the complicated balancing test that courts start looking into to figure out if that private fact is the type of fact that can be publicly disclosed as a function of what you, the possessor of the privacy right and the private fact, what you've done to sort of inject yourself perhaps into that area of perhaps newsworthy controversy. And so that comes from the case Capellas versus Kaufman, reported at 1 Cal 3rd 20. That's a California Supreme Court case. And so the general distillation from this is that media reporting on legitimate news issues is a matter of public concern, and that is legitimate, a legitimate sort of constitutional protection that the media has to report on legit news issues without being subjected to tort liability for intruding into private facts. Now, let's look at another case, and this is another area of when you've intruded too far into private matters. And so we look at this idea of intruding into private matters. based on, we'll take the Miller v. National Broadcasting Co. case. This is from 1986, reported at 187 Calap 3rd, 1463. And our general rule, of course, is that an intentional intrusion, physical or otherwise, into plaintiff's private life, seclusion, or solitude that would be highly objectionable to a reasonable person and causes some sort of adverse effect on the plaintiff, that's generally unlawful. And so here we look at a case, and it's a good case to look at to see where you have what are the limits on news gathering that come from this Miller case. And this is a very important case in the sense that it takes a fact pattern and draws a line and says, even though an issue may at a general level be one of general newsworthy interest, this is an example of the news media going too far. And so here, let's look at the facts of Miller. Miller involved a television camera crew that entered the home of a man who had a heart attack. And so they didn't get permission from the man who had the heart attack to enter the home. They were tagging along with paramedics. And so you got a TV camera crew hanging out with paramedics, and they're sort of creating a documentary or news type show on the work of paramedics and what it's like to be a paramedic and stress, drama, tension, you name it, right? So someone has a heart attack, calls 911, expects the paramedics to show up, understands the paramedics are going to come in and help him, but a TV camera crew kind of tagged along and followed. And they're filming, and the man had his heart attack. The paramedics show up, they help him, but he died. And so what later happened is the National Broadcasting Co. then makes a sort of mini documentary about the paramedics and what happened. And they used that footage about the man, the heart attack, and how he died in their documentary. And what the California court held is that that went too far. While it's certainly the idea of what paramedics are doing and how they help in the stress is obviously newsworthy, and gathering news about it is legitimate public interest. What they also held is that the idea that you can go into someone's bedroom when they've had a heart attack and they are particularly vulnerable, at risk, fearful, and film that and then later use it, that transcended the boundaries. That went too far into someone's private realm and zone of privacy rights. And so what they held is that reasonable people could regard the camera crew's intrusion into plaintiff's husband's bedroom at a time of vulnerability and confusion occasioned by a seizure as highly offensive conduct. And so that's a very, very important case and example of how we have massive privacy rights. And there you have a California court saying that you have a privacy right when you're vulnerable, you're ill, you're sick, you call to get paramedics help. You understand the paramedics that are coming in and help you, but your bedroom still retains a zone of privacy vis-a-vis the news, even if you've given up something vis-a-vis the paramedics. That's an example of that tort. Now let's shift to another form of invasion of privacy, and we're going to look at a Barbra Streisand case. And this is the Barbra Streisand beach property case. So this is an invasion of privacy case that's built around the following fact pattern. There was a photographer who was taking photos from offshore, and some of the photos he took were of Barbra Streisand's private estate on the Bluffs Beach. It's a mega home up in the hills of Malibu. And, Barbra Streisand's home's photographed, and then the photos are published, and she then claimed an invasion of privacy in an invasion of privacy lawsuit that this was violation of Zoom lens laws, and had telegraphed too far into her property, and that this was sort of an invasion of her privacy to sort of peer into from a helicopter coming along the coast of Malibu into her home. Now, the photographer didn't take any photographs inside her house and was actually not a paparazzi, but was using the photos as part of a coastal records project that documented the entire California coastline. And this is at some sort of a website. I don't remember the website, but it was a .org website in the case, you see. And so loads of homes were being photographed, and they were being photographed at a general level like you see there in the photo, not sort of deep and intrusive into the home. And it was for purposes of public works project type thing. And so what the court held is that that was not an invasion of privacy. That's an example of being able to take photographs, even of one's private home, which can be seen from the public space, obviously, without zooming too far into the home. So you can, cruise along the beach, you see a home up there, snap a photo of it, that type of thing's okay. And what the court held, and this is important because this shows the balance between what we may want to assert as our privacy right and the public interest in the ability just to sort of, operate, all manner of entities and people in the public sphere, private and government. And so what the court held is that Occasional overflights are among those ordinary incidents of community life of which Barbra Streisand is a part. And that's a really, really important quote from the case because it gets at the idea that we cannot over-assert privacy rights and interests because any little thing that happens to us, bugs us or irritates us or whatnot. There is actually a give and a take, even with respect to our homes, vis-a-vis being seen or photographed in public. Let's shift to now the other tort that we talked about, which is, in the context of privacy rights, which is false light. And here we have the general rule. And the general rule is that it's unlawful to disseminate information about someone that may be false or erroneous, or that places the person in a derogatory and false light that would be offensive to a reasonable person. And so this is an important aspect of the privacy right to, at some level, not be defamed. It goes hand in hand with defamation law to some extent. And specifically, though, and more broadly, it's this specific idea that you should not be painted falsely in a damaging, wrong way that could be offensive to other people. And it's a particular tort that's distinct to defamation. There's massive overlap, obviously, and both claims would be brought. But it is a very specific aspect to privacy that you don't get to have people paint you and push you into something that you're not in a manner that could hurt you. And so a very, very good case to look at. And the reason for this, of course, is that it intrudes and damages your core root personhood, which is an aspect, as we saw in all the quotes from the prior cases, about one's privacy right. And so this case is MG versus Time Warner Inc. from 2001. It's reported at 89 Calap 4th, 623. And this case involved news stories that were then published by, ultimately Time Warner media outlets. But these are news stories about a coach who was convicted of child molestation. And so it was factually true that a coach of a Little League team was convicted of child molestation. And that obviously is an interest that is a story of interest and newsworthy to discuss and talk about in the news, obviously for the press. But in the articles about one coach who was convicted of child molestation, the news stories included photographs of the Little League team, the whole Little League team that the defendant had coached. And so you can imagine, right, there's a photograph of a whole bunch of kids, and then the coach, who was the one convicted of child molestation, and other coaches, the assistant coach, the team mom, whatever it may be. I don't remember exactly who was in it, but there was certainly an assistant coach. And so this lawsuit then is brought by the players who were not molested and the assistant coach. And what the court looked at this and said is, look, while the coach may have molested someone on the team, it's not okay to put a picture of every kid up, which implies now that all those kids were molested, and those kids who were not molested don't want to be told or have people think that they were molested. That paints them in a false light. It injures them and damages them. That's not what happened to them, right? Ditto for the assistant coach, who's looking at it obviously from a damages perspective from the other way, saying like, my God, I didn't molest anyone. I wasn't arrested. I wasn't convicted. But you got a news story about coach molesting kid, and there's a picture of me with the team. Holy cow, everyone thinks I'm a molester. That's horrendous. And the court said, yeah, absolutely. It's a false light claim. And Time Warner was in serious financial trouble, obviously, vis-a-vis the plaintiffs for that, because that is a tort that damaged their privacy rights in terms of not being painted in a false or erroneous light, either as a perpetrator of a crime or as a victim of a crime that one wasn't a victim of. And that was, the court held, as a matter of law, simply offensive to any reasonable person. And so that is another example then of state tort law and how it runs into your personhood and your privacy rights. Now let's shift to the last aspect that we talked about of privacy rights emanating from state tort law, the fourth major category, and that's the right of publicity. And this gets at rights to protect one's persona, their name, their likeness, their image, how you look, how you sound. You have rights in that vis-a-vis exploitation by others for commercial purposes. And so the right of publicity emanates generally from statutory law in many states, but also the common law of many states, but not all states. So some states don't actually have this specific tort right of a right of publicity against commercial exploitation. And what it generally is, and because it varies by state, I have just a general rule of it here, But if you're interested, we have a Curious Lawyer program on dead celebrities and the right of publicity, where you get to learn all about James Dean, Marilyn Monroe, and you name it, and everything about the right of publicity. But nonetheless, here's a general summary. It's the right to protect against the unauthorized use of one's name, image, likeness, or voice for commercial gain. And so the root right stems from this right of publicity, that every person has the right to control the commercial use by another person of his or her identity. So I'm obviously not a celebrity. I'm just some lawyer practicing law in Orange County, California. But even I, not as a celebrity, just as a regular person, I have the right to protect any third party's commercial use of my name, image, voice, or likeness against exploitation. So in other words, someone can't just go out onto the internet, find a picture of me or a video of me talking, and then use that to commercially sell their product. Not that anyone would want to use mine, but nonetheless, can't do it. I have that right of privacy, which is known as the right of publicity. Now, these rights vary by state. They can be 10 years to 100 years post-mortem, depending upon who the person was and whether they were a public figure when they died. And it even matters where they died as to whether you have different rights. And at root, what you see, if you go to that Curious Lawyer program I talked about on the right of publicity, you'll see that these different state rules are so broad and different that we've got this sort of hodgepodge of rules all over the place that's hard to even unpackage sometimes as to what rights exist. But at root, in most of the country, most of the time, there is this right to have control over people's exploitation of our persona for their commercial gain. So we're going to look at a couple cases that explore this, and these are celebrity cases, and these are the cases that get litigated the most, obviously, up to sort of published opinions at least. And the first one we're going to look at is that one aspect of one's personhood that you have the right to control, and that's your voice. And this is the Bette Midler case. And this is Midler versus Ford. It's reported at 849 F. 2nd 460. It comes out of the Ninth Circuit in 1988. And so here are the facts of the case. The Ford Motor Company wanted to create an ad campaign for their Mercury Sable car, and they wanted to inspire nostalgic sentiments through the use of famous 1970s songs that would be sung by the original artists. And so they went to Bette Midler and said, hey, can you sing a song for us in our commercial, the song Do You Want to Dance? And it was one of the songs that she had sang on one of her early albums. And she said, no, I don't want to sing that song to help you sell those cars. I'm not interested in using my voice to help you in that way. And so the Ford Motor Company was not going to be stopped, and so they went out and they got a voice impersonator, someone who could sing that song and sound like Bette Midler. And then they had that person sing the song. It sounded like Bette Midler. They made a commercial for their Mercury Sable car, and they were able to do it, and that's another copyright. If you want to learn more about copyright law, go to our Curious Lawyer copyright programs, where we've looked at U2's music so you can understand everything about copyright law, even while listening to U2's music. You'll understand then this issue that they were able to get the rights to the copyright to the song because Bette Midler didn't own it, and so then they just hired a voice impersonator. Now, Ford said, we never used her image, we didn't put her face up, we didn't do any of that, it's just a voice impersonator, and we had the right to use the song from a copyright perspective. Nonetheless, Bette Midler sued and said, you used a voice impersonator, and it gives the impression to the people seeing the commercial that I am sponsoring Ford, and I have a right to control that aspect of my personhood, that I am not a sponsor of your car without wanting to be a sponsor of your car. You can't appropriate that out of me. That triggers my privacy right. And the Ninth Circuit agreed with Bette Midler. They held, why did the defendants ask Midler to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct her to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of Midler's identity. Its value was what the market would have paid for Midler to have sung the commercial in person. The human voice is one of the most palpable ways identity is manifested. And so this is a very important and exemplary case, really, of the idea that our privacy rights can be narrowed all the way down to just our voice, literally your voice, without any other attribute of your personhood being appended to it. But if your voice is distinct, even if it's not particularly distinct, it's just your voice, it can't be used for commercial gain if the voice is somehow being tethered to your personhood. Let's shift now to another case, and this is the Vanna White robot case, and this is White versus Samsung, and this again comes out of the Ninth Circuit. It's reported at 971 F. 2nd, 1395. It's from the Ninth Circuit in 1992. And this involves another aspect of privacy rights within the right of publicity, and this is likeness. And when we're talking about likeness, this is a good case to use because this case had Samsung using what is a robot, but it's a robot lookalike of Vanna White. So unlike the Midler case, which only took Midler's voice, this case is not taking Vanna White's voice, nor is it even taking an exact replica of Vanna White, like some sort of a digital avatar or something that was a perfect reproduction. It's a robot that kind of looks like Vanna White, and because the robot was sort of turning letters on a board the way she does in the television game show that she's on, it obviously was intended to be Vanna White, and so it's trading off of her likeness. And so this is another, you get super narrow in the right of privacy, right? We're now down to one's likeness, sort of that emanation of them that sort of looks and appears like them, even though it's technically not them. And Vanna White was unhappy because by taking that specific aspect of her privacy right, her likeness, it created the idea perhaps that she had authorized that use of her to help sell Samsung products in commercials. And so, you see there a picture of her being used that comes from the commercial, and it was some Samsung ad to sell their, computer, products or whatever they were selling in 1992 exactly. But it's a wig and jewelry, and it's next to a Wheel of Fortune board, and it's obviously, presented to resemble her next to a game board, and it was instantly recognizable as her. And so she sued under California right of publicity law. And here, the Ninth Circuit held as follows. Television and other media create marketable celebrity identity value. Considerable energy and ingenuity are expended by those who have achieved celebrity value to exploit it for profit. The law protects the celebrity's sole right to exploit this value, whether the celebrity has achieved her fame out of rare ability, dumb luck, or a combination thereof. Because White has alleged facts showing that Samsung had appropriated her identity, the district court erred by rejecting on summary judgment her common law right of publicity claim. And so that's a great example of how that is the type of use of someone's likeness that the court's protected. And what's important about that holding you see there is that it's not rooted in the idea that Vanna White had privacy rights because perhaps she's done some amazing thing like Einstein or something like that. It can be luck. It can be like rare acting talent ability. It could be a combination of luck and ability. So it doesn't really matter the sweat equity value of what it may be. The court isn't going to make some sort of artistic judgment about that. She absolutely has that right, period. And so it's a very important case to explain and understand that these privacy rights that take root in the right of publicity against commercial exploitation are very, very important aspects of our personhood. So we've talked a little bit about some of the zoom lens laws and the paparazzi in terms of what are the limits in terms of what paparazzi can do when they're taking photographs. And so we saw from the Kennedy Onassis case that they can take photographs in public, they just can't endanger people or go into private spaces and take photographs. And so there is this public sphere for news gathering that's legitimate. You see, Jackie Kennedy walking down Fifth Avenue from a distance. You can snap a photo of her on the public street. That's fine. She's in public. Now we're going to look at laws that have been enacted to deal with, again, technology advances. And so it's another kind of example of where we get to this idea that as technology evolves, it butts up against our privacy rights and concerns. And so California has enacted zoom lens laws. Other states have too. And at some level, you can understand these as anti-paparazzi laws. And they deal with the idea that there's constructive invasions of privacy if people attempt to capture, and you see here the law from 1998, if they attempt to capture in a manner that's offensive to a reasonable person any type of visual, image, sound recording, or other physical impression of someone engaging in personal or familial activity under circumstances where the plaintiff had a reasonable expectation of privacy. So let's just pause there. If you use a camera you can see the house from the street, but even standing on the public street, you zoom in and you through the window and there's I don't know, maybe it's Bette Midler eating lunch with her kids or spanking her kids or who knows what, right? That is an intrusion that's not okay under these zoom lens laws, even though there's no physical trespasses, you see. So the point is, if you couldn't have got this unless you used some technology enhancing device like a zoom lens or maybe even heat technology to look through the walls, whatever it may be, right? That's unlawful. And these laws were enacted in the late 90s, and in 2009 they were extended really in terms of the net, in terms of who'd be ensnared for liability, and it includes those who induce other people to do it. And so that would include media outlets like gossip websites, tabloid blogs, and the like that know and induce others to sort of go and obtain photos illegally of people in their private homes. And so these zoom lens laws act as restraints on behavior from the person who may be sitting in a public space, but intruding digitally, not physically, but digitally into private space. And so it's another aspect of privacy. But now let's shift to New York, and we're going to see some limits, again, constitutional limits that end up emanating on even that idea of what you can photograph when you can photograph someone in their home. And so this is the famous Neighbors case, and it involves the artist Arnie Svensson, and this involves New York privacy law. And so here, the artist was just in public on New York streets, and he took photos. It wasn't a zoom lens into the home, like, necessarily, but it wouldn't have mattered for purposes of this case. But there were just New York residents going about their business right in front of their windows, on the major streets of New York and whatnot. And those residents were in their homes. These are lower Manhattan apartments. And he used, either regular lenses or telephoto lenses, and he didn't have their consent. And so you see there are a couple of the photos. I mean, there's, someone that looks like cleaning the floor or doing something. Another person is just lying on the couch there, their T-shirts up a little bit and a bit of their backs exposed, taking a nap. And that's all visible from the public space. And so he took those photos and held an art show, and this was part of his art show and exhibition that's built around the idea of sort of just people in, going about their business in the solitude of their homes and sort of what it means. And it's sort of it's an artistic show. Now, some of the subjects obviously weren't happy, and they sued. And they made invasion of privacy claims saying that, you don't get to do this and reach into my home like that and use that. And the court ultimately held that he had a protected artistic, rooted in the First Amendment, this protected right to engage in creating art. And this was not done commercially. They weren't using those photos to sell, cleaning supplies for the person on the lying, or what a great comfortable couch it is. It wasn't being done by the commercial entities that could otherwise perhaps exploit those photos. This was done for art. And because it wasn't for sort of commercial purposes, it was for art, it was also found that it wasn't offensive enough to a reasonable person to constitute an invasion of privacy. And so there you can see an outer limit example. The case was obviously very, very controversial. People are on both sides of the fence there. All you curious lawyers may be on both sides of that fence. But that's an example of where there become limits. And so I guess the practical advice, if you're at a cocktail party and you're in New York and you want to talk about privacy rights to people in your state, you may want to tell them to close the curtains so they don't show up in someone else's art show. So now let's pivot, and I want to talk about social media a little bit. And here we have, you remember that Justice Brandeis quote in the beginning about this technology privacy rights tension? Well, it sees and rears its head a lot in social media. And social media has terms of use that if you've ever read them, you'll know. If you haven't read them, go read them if you want to use social media, because the contracts themselves, you give over basically everything. And so this itself is dampening the very expectation of privacy that people have for what should be allowed and shouldn't be allowed from third parties. And this affects then the baseline cultural perspective. And I think this is critical because from the law's perspective, as we've already seen, what our privacy rights are can shift vis-a-vis technology in the court in terms of how the court perceives the viability or propriety of what technology is doing. And so if we more and more develop and abdicate more and more of ourselves to the public or the private spheres, we will find in time, I think, courts and jurists looking at it more and more saying, there's not a lot of privacy rights out there. Real quick before we conclude, we can look now at 2022 and some very advanced statutory protections, and this is its subject of their own CLEs. They're very, very complicated privacy statutes, but California as well as Colorado and Virginia have enacted some statutes that give European-like privacy rights, and these are very important rights to consumers and households vis-a-vis businesses of certain sizes when they're gathering information about people. And it gives people the right to know about personal information that's collected against them, the right to correct it, the right to limit the sale and use of it for commercial purposes, and even in some instances, the right to delete. And so these are very, very advanced statutes that are really now pushing the other way, saying that we have to sort of gain back some of this ground that's been given up to technology media companies from a privacy perspective. And these, again, are statutory enactments that are focused very much on sensitive personal information like geolocation, ethnic, racial origin, religious, philosophical beliefs, even genetic data, whether one's in a union or not, that type of stuff. And so these are fundamentally statutory enactments that are being enacted to gain back some of the ground that perhaps has been lost. So there you have it. This brings us to our conclusion. There is no specific constitutional amendment that actually says you have a, quote, right to privacy, end quote. But we've seen a whole bunch of turf that gives a lot of rights, and we've seen the shifting court over time on it. We are at our expansive peak right now, but we're all waiting to see what happens to Roe and Casey in the coming years before the Supreme Court, and whether we are now going to have a different playing field of privacy rights there. We've seen state tort law and how it protects it, and we've seen First Amendment limitations on that state tort law. And so what we're really left with is these massive questions on the horizon about digital data and how we can protect it. We're all creating so much of it that's private about ourselves, and what are the limits? And so those 3 states I mentioned have enacted laws. More laws may be enacted. And then, of course, we have drones, tracking devices, and the like. Technology is going to advance. And I think what we're going to see when you get to Privacy Lawyer Part 2, The Curious Lawyer, in a few years, all of those Justice Brandeis quotes, I'm going to tell you again, they're even more prescient than we thought they were the first time. Thank you very much for listening to this program. If you have any questions, email me as always. I'd love to hear from you. Have a good day.